Ladies and gentlemen, good morning. I thank the IORA to have given me the chance, the opportunity to be here, and the IDSA for making all the warm welcome and logistic support for the delegates here. So my presentation is mainly inputs that I received from the legal experts from the Attorney General's Office, the Shipping Division, and the National Coast Guard. And my deliberation will be mainly on Mauritius and its policing implications, Mauritius, its EEZ and the extended Continental Shelf, maritime security legislations and conventions, the ships and port security, preventing measures taken, and the regional collaboration that we all will require. So, in terms of Mauritius and its policing implications, Mauritius is a small island, as you know, small state in the Indian Ocean. It has an ocean territory very vast, in large disproportionate to its land size, with an exclusive economic zone of about 2.3 million kilometers square, including an extended continental shelf of 396,000 kilometers square in the region of the Mascarene Plateau, jointly managed by the Republic of Mauritius and Seychelles, outside the border of the respective EEZ. Now, focusing on its ocean economy, this will result in increase in port connectivity, increase in maritime traffic in this part of the region in terms of number of vessels transiting through our maritime zones. Now, let us see the EEZ of Mauritius and the extended continental shelf. As you see, Mauritius has a large extent of continental shelf, and this has much implications in terms of maritime safety and security. Now, let us see about maritime security. Mauritian industry has been affected by piracy, as you know, lately. Our ships travel areas frequented by pirates. There have been increase in shipping costs due to high cost of insurance premium. Fishing and tourism industry victims of piracy acts. But the Mauritian government has taken very action to counteract this major issue to ensure maritime safety and security, be it at sea or at the port. Now let us see the legislations and conventions to which Mauritius is party to. Let me take the Prevention of Terrorism Act, the POTA, 2002. It makes provision for new offenses in our criminal law relating to terrorism. It introduces measures with a view to gathering intelligence, carrying out investigations, and ensuring enforcement in the matter. It provides also for a mechanism of cooperation with foreign jurisdiction. At the same time, it seeks to implement the international commitments of Mauritius in respect of terrorism. The Prevention of Terrorism Act special measures provides for the central bank or the Financial Services Commission to give directives to financial institutions for the freezing of assets and funds of suspected international terrorists and terrorist groups pursuant to Part 2, Section 10(6) of the POTA. The Act also clearly lists the offences pertaining to funds, financial assets, and economic resources held in the favour of terrorist groups by nationals or by any person within the territory of Mauritius. Now, the Geneva Convention Amendment Act, it incorporates into our law the humanitarian obligations assumed by Mauritius and which has been set out in the Geneva Convention. Protocol 2 covers victims of non-international armed conflict. And provisions of the Geneva Convention may become relevant when authorities in Mauritius are dealing with persons detained for terrorist offences. The latest amendment affords extraterritorial competence to Mauritian courts, and in this sense it joined the regime of extraterritorial jurisdiction provided in the Act. The amendment also criminalizes the act of using Red Cross emblem or any other emblem without the consent of the minister. The legislation also provides for the protection that the protecting power must ensure to a protected detainee under the Geneva Conventions. Now, the Civil Aviation, Hijacking and Other Offences Act, which is commonly referred to as CAOA, it incorporates, among others, the following UN Convention into national legislation. The Convention for the Suppression of Unlawful Seizure of Aircraft signed at The Hague in 1970, and this came into force in October 1971. The Montreal Convention for the Suppression of Unlawful Acts Against the Safety of Civil Aviation, which was signed at Montreal in 1971. The COA also brings within its jurisdiction other offences that exist in the penal law, namely assault, larceny, manslaughter, murder, unlawful detention, wounds and blows, of which are offences in the Mauritian Criminal Code. It also claims jurisdiction over possession of firearm, which is an offence under our Firearm Act. Now, the Continental Shelf Act, 1982, it incorporates the protocol of unlawful acts against the safety of a fixed platform located on the continental shelf. It also concluded in Rome in 1988 into Mauritius legislation, and therefore adequately satisfies the legal requirements of the convention. The Firearm Acts aims at administrative and legislative control relating to firearms. This act is reviewed entirely to incorporate our obligations under the following protocols of which Mauritius is signatory: the United Nations Programme of Action, Bamako Declaration on an African Common Position on the illicit proliferation, circulation and trafficking of small arms and light weapons, Protocol against the illicit manufacturing and trafficking in firearms, Protocol on the control of firearms, ammunition and other related materials in SADC region, signed in August 2001. The Immigration Act. This act provides for the establishment of a list of prohibited immigrants who shall not be admitted to Mauritius, especially persons involved in criminal activities, trafficking, drugs, etc. Now, the Immigration Act does not make provision for asylum, but in fact, Section 8 of the Act has been amended by POTA to include non-citizen declared suspected international terrorists as prohibited immigrants. The Customs Act. This empowers the custom officers to arrest persons involved in the commission of smuggling, importing, and exporting prohibited goods, which are criminal offences in Mauritius. The Piracy and Maritime Act. The Piracy and Maritime Violence Act 2011, it provides for a comprehensive framework for prosecuting in Mauritius persons suspected of having committed piracy. It includes provision for the prosecuting of suspected piracy, hijacking, attacks committed elsewhere, handing over and taking over pirates protocol. The Republic of Mauritius has also ratified this convention, and an agreement has been entered with the European Union in July 2011 for the transfer of the suspected pirates. The Piracy and Maritime Violence MOU between the UK and the Northern Ireland and Republic of Mauritius Regulation 9 2012. This allows for the transfer of persons suspected of attempting to committing or having committed acts of piracy and captured and detained by UK forces associated with property seized by UK forces to Mauritius. The Suppression of Unlawful Acts Against the Safety of the Maritime Navigation 1988. The Republic of Mauritius has ratified this convention as well as its protocol. Furthermore, this convention resolves the problems posed by the limitations of the UNCLOS. There is recognition that unlawful acts against the safety of maritime navigation jeopardizes the safety of persons and property, seriously affect the operations of maritime services, and undermine the confidence of the people of the world in the safety of maritime navigation. Other relevant conventions, mainly for assistance from other state parties, including procedures for permitting ship boarding, etc. There are various conventions, but I'm just naming 3 of them. Protocol for the suppression of unlawful acts against the safety of fixed platform located in the continental shelf, International Convention for the Suppression of Terrorist Bombing, adopted by the General Assembly of the United Nations in 1997, International Convention for the Suppression of the Financing of Terrorism, adopted by the General Assembly of the UN in 1999. Now let us look at the maritime.
4 minutes. Can I request you for both your
yeah. So let me just give something on the ship and port security. For the implementation of SOLAS, Chapter 11.2 and the International Ship for Port Facility Security Code, ISPS code, this is at drafting stage in Mauritius. Let us see the preventive measures taken by Mauritius, setting up the commando force for the National Coast Guard, the fishing vessels fitted automatic identification system, satellite phones and radio and other system, Maritime Information Sharing Center, code for facilitating transnational communication. So there, you can see on all the other facilities measures taken. Now I'll dwell on the regional collaboration. These are the recommendations that we say. We may have many legislation and conventions signed, but predominant insecurities at sea emanate from non-traditional threats. There is urgent need for regional collaboration among the member states of the IORA. There is need for information sharing. And I would say also it would be good to have a group of experts together, working together and like a think tank, and see how we can come up with implementable solutions. The review of existing legislation also may be felt with a view to better meet the challenges ahead. Therefore, there would be need for capacity building for our legal experts to better equip them in their tasks, and also capacity in marine forces and those who are involved in enforcing the laws and regulations to better have marine security and safety. So thank you for your attention.
Thank you.